I'd like to introduce Professor Heather Douglas from the University of Melbourne, who has a background in the Australian Feminist Judgments Project and also the Indigenous Judgments Project. And Heather, I was wondering, to start us off, if you could talk about your background as to being involved in these rewriting or reimagining judgment projects.
Sure. So I started off as a lawyer working first in private practice and then at the Aboriginal Legal Service in Alice Springs for a few years. And then I turned up in Brisbane and got a job at Griffith University to run a pre-law program for Aboriginal people for about 5 years, but gradually sort of segued into mainstream legal academia. And in that context, really, my interests were marginalisation, really, and how people were left out of the law. So women, Indigenous people, people with disabilities, and that's kind of the work that I've done within the frame of criminal law largely. So certainly feminism has been something that has been part of my thinking about myself and my work for many years, even going back to being a university student and then as a lawyer and more recently as an academic, but although it's not that recent anymore. But and so when I was in Brisbane, I moved from Griffith to UQ and left a bunch of my colleagues behind. And even though they're at a university just over the other side of town, we kind of didn't see each other as much. So we set up this feminist reading group and we got together every month or so and read an article, kind of feminist legal journal article, and chat about it over dinner. And that kind of got us talking about a new project from the UK that we came across, which was the one led by Rosemary Hunter and Erica Rackley and Claire McGlynn, the English project. And that was really interesting. And we looked into that, and then we read some things from the Canadian Women's Court, and that looked really interesting. And we thought this would be really great fun. Really interesting to see what we could do with this in the Australian context. So then we kind of got a group together from our reading group to sort of start to pitch this idea around to colleagues in other universities, and we sent out a call through all of the people that we knew and also through the deans of research in the law schools to get out to anybody who might like to contact us to be potentially involved in the project in some way. And we were pretty amorphous at that point about what it would be. And we eventually had a workshop at UQ. I think that must have been about 2010, quite a long time ago now. And we talked about what we might do. And there was a group there who were pretty interested in the English project and maybe revisiting that in an Australian context. So we put in an ARC grant and was successful. And then the project began. So we were always really keen to make it a collaborative project, really ground up. So that's hence the sort of really broad call out. And we wanted to make it feminist in terms of its methodology, essentially. So inclusive and ground up. And they were kind of our keystones for the work. And so all the way along, we were kind of driven by the people who were interested in the project as to what they wanted to do. So we mostly didn't tell people what to do. The exception to that is we did specifically invite some of the sort of key legal scholars, legal feminist scholars in Australia to be part of the project to make sure that, you know, they were represented in this book too. We thought that was really important. And yeah, we took it from there. So people selected their own cases, and we tried to put people together who just expressed interest in doing something for the project to be commentators if they didn't want to write rewrite a case. So that's kind of how it all came to be. We were also really conscious, we thought at the very beginning, that we wanted this to kind of be able to contribute to law reform. So we wanted this to kind of produce tools for judges to use in real life to show them that they could do things differently. So we set up pretty strict rules like the Feminist Judgments Project did in England that required people to abide by the rules of the time in relation to writing their judgment. So they could draw on research, but it had to be available at the time the judgment was made. And it had to use existing rules and so on. But even still with those strict rules, we still got some really creative judgments out of that. So that was really interesting. We also were obviously very kind of focused on our context, which is obviously Australia and Indigenous community in Australia. And so we thought it was incredibly important to have Indigenous people involved in the project, and one or two perhaps came forward, but we approached others. In any event, at the end, we had 3 Indigenous people also involved in the project that wrote judgments, in inverted commas, interestingly, I think, they couldn't write judgments. Any of them couldn't write judgments in the strictures of white colonial law. No surprises there in some ways, but they couldn't do it. So they did things differently. So, and they all chose different ways to do things that had with a feminist voice. So that was a really interesting part of the project, I think, as well. I think that's kind of how it all began and how I got involved with it.
That's a very helpful background and very helpful context, Heather. And I really want to extend on some of those points. One about plausibility, which I think is one of the hallmarks of the Feminist Judgment Projects, that the idea is that the judgments that are reproduced are legally plausible.
Yeah.
But then the counterpoint to that, of course, is some of the participants, particularly the First Nations participants, felt that they weren't able to reproduce that system. So And I've elsewhere said, I think that that's one of the strengths of the project, that you see what's possible within legal formalism. I'm really interested in coming back to this point of what constitutes a feminist judgment and what kind of rules you put in place there. So I understand.
No rules. So we didn't have any kind of feminism that we said was the feminism that we were going with here. We asked participants to use a feminist lens, and that was the instruction around that. What did that mean? That was something that they had to think about and determine. And obviously within feminism there are different schools of thought as to what feminism might be, and that I think is reflected in the judgments. So, for example, some judgments do reflect an ethic of care, so drawing on kind of the voice, the relational voice, and so I think that comes out in a couple of the judgments. Other judgments have a notion that human rights are feminist, so there's this notion of human rights using a feminist lens. Others really had a view that legal positivism, the formal approach to the law, really applying the rules strictly, actually would lead to justice. And so the problem was not that the rules were the problem, but the application of the rules in some cases had been the problem. So some of the judgments, there's a family law judgment, for example, that applies the rules strictly, and they come out with a feminist answer, which for that judgment puts a woman in the centre and her needs at the centre of the judgment. So there were different approaches across the judgments. Some of them highlighted bringing women back into the case. So a lot of criminal law judgments, for example, often refer very obliquely to the victim in the case, and they're often a woman. And so bringing that woman back into the case so she is a fully human being with a name and a voice within the judgment was really important for some of the criminal lawyers. There are also other issues around this notion of ordinary person and what ordinary people think, and this idea in law that ordinary person has really been imbued by masculine qualities. And so to think about what an ordinary person looks like through a feminist lens was the challenge for people like Annie Cozzens, for example, in her evidence judgment. So really different approaches across different judgments were taken by people. I don't think it's not really possible to say that there was a particularly consistent approach here, I don't think. I mean, we say in the introduction that, we talk about Rosemary Hunter's research, and obviously she was an editor of the Australian project as well. And we talk about her research in the introduction and the kinds of 6 or 7 points she makes about what makes a feminist judgment. And I think most of the judgments have at least some of those kind of rules or points within them. So, including women, for example, is certainly something that some of the judgments do. Some of them ask the question about, the woman question, what happens to women here? So there's a tax judgment, for example, about childcare and fringe benefits essentially, and childcare being a fringe benefit or not being a fringe benefit, how that should be taxed. So if you ask the woman question about that, you might get a different answer in that case than if you ask it from a male perspective. So certainly that was visible in some cases as well. I think contextualising and particularising is something else that Rosemary talks about. And there's a judgment, for example, to Keto, which I remember well, and that was a case where a woman was carrying mace, I think, for self-defence, and she was charged in relation to having an offensive weapon. But what the case does, it contextualises and particularises her particular circumstances at the very beginning of the facts, so that we can understand why she was carrying mace. So I think a lot of the things that Rosemary suggests in her work around what makes a feminist judgment certainly were part of it, part of many of the judgments in the case, but they didn't all have all of those features.
Of course. Did your thinking about what constituted a feminist judgment evolve over time?
I suppose I probably hadn't thought about it a lot as to what I would do if I was a judge. I mean, unless you're writing judgments, you probably don't think about how you would do it differently necessarily. I mean, as academics, we're really used to sort of critiquing judgments and saying what's wrong with them from our particular perspective, feminist or otherwise. But actually coming up with an alternative judgment often isn't something we aim to do. So that whole process of articulating what a feminist judgment would look like was really interesting. And I think the diversity of approaches was really interesting to see. They're really, across all of the judgments in the feminist project, some of the differences are quite slight, but nevertheless, there's a real diversity of things that kind of adds up to something being seen through a feminist lens, I think, which is really good. So it opened up my ideas about what could be a feminist thing, I suppose.
I think the point about the difference has been quite slight is a good one. I'm thinking of the case of PGA about marital immunity for rape, and that the reimagined decision, actually the main difference was offering an apology to the women of Australia.
Yeah, look, that's right. And I mean, that's something that always I think is different about being a judge to being an academic, is that we can sit there and we can critique a case, but when you're a judge, you're thinking about an answer in this case, but the answer you give in this case has ramifications for all other cases or for many other cases. So you really need to be able to think beyond this just single decision. And I think that was the challenge for the people running PGA. Wendy Larkham and can you remember who the other person was? I can't. Mary Heath and Wendy Larkham. The challenge for them definitely was that if they found in favour of the woman in this particular case, there was some kind of denial for other women. So these kinds of decisions are really interesting and very nuanced in terms of what makes it feminist. And so they dealt with that problem, as you say, by introducing an apology. So the results often weren't different. In most cases they were, but in many cases they weren't. And, there's a case in there too, Parker and the Queen, which is a early sort of provocation case that Adrian Howe rewrites. And she goes back just a tiny bit further in precedents, just one or two cases back further in precedences, and highlights that precedent, and that takes the case in a whole different direction. So I think that these things are really interesting to explore and show you in some ways the flexibility of the common law, but also its fragility in some ways as a methodology. Justice is a choice in so many cases that can be made. And I think that's a really interesting sort of radical proposition in some ways.
Thinking about the art and craft of judgment writing, and I think that's one of the really interesting features of these projects, is that it's not always, but it's usually academics who are rewriting or reimagining judgments. And as academics, we don't write judgments. As you say, we're in the process of critiquing judgments. How did the contributors grapple with some of those difficulties in terms of wearing the judicial robes, imagining themselves as judges, and writing something that read as a legal judgment and was plausible as a legal judgment?
So we had a bit of a systematic approach to the writing process, which we assisted people with. So we had a workshop. We ran workshops in several states, and we had a workshop, the initial workshop with judges, and judges gave tips to the people involved in the workshops about the issues they might face. So finding your voice, telling the story of the participants, putting the story before the process, a whole range of sort of tips that those judges used in terms of writing judgments, things like knowing who you are, knowing what your biases are, and being upfront to yourself about your biases so you can deal with them properly in the judgment, so that you're thinking about the facts, knowing what your biases are. So a lot of those kinds of things were talked about by actual practicing judges in our early workshops. And then in the second workshop, people came back with drafts, and we had more judges critiquing and reality testing our drafts. And the reason we did that was because our project was trying to be real, real alternatives to the judgments. So we wanted them to be legally real and to abide by the rules of the time and so on. So this reality testing by current judges, I think, was really helpful. But I do think a lot of people struggle to write judgments as the particular form. And I recently wrote a judgment for the Indigenous Judgments Project with another scholar called Heron Loban. And I was mindful of someone, Jenny Nielsen, in the Feminist Judgments Project, who said she started writing the judgment by using the text in the actual judgment and rewriting that, striking out things and filling them in with different words and things, before she realised that actually she had to throw that judgment out and think about the facts and rewrite the judgment from scratch, and then edit the judgment into judicial speak, rather than just play around with an existing draft that someone else had written to try to make it feminist. So I thought that was a really good tip, because of course that's what judges do. They don't rewrite someone else's judgment, they write their own judgment. And so that was really important. And also I think dropping the idea that you had to actually decide differently, that you had to make a different decision, that a lot of the problems with the judgments we're unhappy with are not necessarily the decision in terms of the decision's effect on a whole range of potential cases, but the way they're written, the way they talk about women, the way they talk about assumptions and so on. So I think when people dropped the idea that they actually had to have a different result, that was really helpful as well, because then they could focus on how they said things and they could write through to a decision, which was another tip that the judges gave us at the workshops, is that you have a problem and you write through to the decision and you use the law and you get to a decision. And the decision might not be what you've expected when you started out, but you write towards that decision. And so, and it's the way you write as a feminist that can be the difference here, rather than the actual result. So, and the resources you use to get to that decision as well. And obviously Adrienne Howe's example of precedent, but also others' examples, like Beth Gay's, for example, in her particular case that she wrote about employment of teachers, she used different resources to sort of underpin her argument. So those things can, so different kinds of reading speeches or research that is available that has been discussed and so on. So, what you use on your way to your end point might be really important as well, and might show up different assumptions, use different language, put the woman who's involved in the case in a different light, for example. So I think all of those things were really important tips from the judges. I really felt that they were very helpful in terms of setting us on the path. We also, and I have to highlight the extraordinary support of Sally Brown, both through the Feminist Judgments Project and more recently through the Indigenous Judgments Project. She's just really got the project and been really supportive in terms of reality testing the feminist judgments. She was wonderful. So yeah, lots of support, I would say, towards that end of writing.
It sounds as though it provides a whole new level of insight and respect for the difficulties associated with the judicial role and constraints of the role, and working through that as feminists.
Yeah, look, I think that's right. And certainly one of the parts of the project was actually interviewing judges who'd been outed by others as feminist or had outed themselves as feminist, and talking to them about the constraints and the differences in the way they approach their role. And that was really interesting as well. I mean, that didn't go into the actual edited collection of feminist judgments, but it was certainly really interesting for me to be involved in those interviews and to hear the different things people said. One judge, for example, is very small in stature, and she does a lot of criminal cases. And so it's not going to work for her to speak back to these large, blustery male lawyers in a loud voice. because it's still going to sound soft and small. So her view of to exercise power and control in a court, well, that sounds terrible, but to exercise some authority in a courtroom was to soften her voice and speak in a very low voice, very quiet voice, so that everybody would have to really strain to hear her, which would mean they'd have to settle down. So interesting how you do authority as a woman in these contexts as well. So I think many of these questions were really interesting to talk about.
That example reminds me of Ruth Bader Ginsburg's approach.
Yeah.
Yeah.
Exactly. Yeah.
Sounds decent. And finally, Heather, have you got any final advice or insights that you provide for those of us embarking on a project in the international arena? Anything that you wish that you knew before you embarked on these projects?
Well, I probably found, in a way, I think the constraint of the rules was not ideal in some ways, because I don't know that it's been used by people who aren't feminists in the way we might have hoped. We did get a review in the Journal of Judicial Administration, which I think went along the lines of something like, this is a fun project, which it was a fun project, but we saw it as a much more serious project at the same time, which I don't know that was picked up. So I sort of felt like it was in some ways, it was a lost opportunity to really challenge the system and to come up with different ways of doing things. And I think in the project, we, the 3 Indigenous participants in the project, the only way they were going to be involved in the project is if they were allowed to be creative and think of other ways to do justice. And so the 3 of those participants did do things differently. And I think as a result, and I want to highlight Nicole Watson's judgment here, we really got extraordinary ideas about what could be just and change in this space. So I think probably the creativity point is really important. And I'm now involved with Nicole in this new project, the Indigenous Judgments Project, which is coming out in June. And that has been almost entirely, the judgments are written quite creatively. And that's been wonderful, actually, and quite exciting. So I guess different ways to do things, but I did enjoy the kind of creativity of the Indigenous Judgments Project. Having said that, I think I learned a lot from the more kind of, I guess, conservative approach of sticking within the rules. I would say, though, the best part, from my perspective, of the Feminist Judgments Project was the collaboration of it. It really was an incredibly collaborative project right from the very beginning. And on that sense, I think the methodology was very feminist. I mean, I think it was really inclusive, and people look to each other to get help and critique and support. So that was really wonderful. And it was a really good bonding exercise between the judiciary and academics. We didn't set out to only have academics writing the judgments, but that's who ended up coming through with their things on time and actually committing to the project. And that makes sense. I mean, academics, that's part of their role. So, and practitioners obviously are doing juggling a lot of other things. So yeah, but I think that collaboration part of it was terrific, actually. And the fact that we could check in with each other over a sort of 2 or 3 year period and come back together and grow as a group was a really quite inspirational thing as well.
It sounds like a really important and interesting thing to be part of.
Yeah, it's great.
I really love, but I'm challenged by the whole tension of the project, which reminds me of Carol Smart's work more generally about how feminists engage with the law and whether, and the way to do that and how radical we should be. So there's some really big picture questions, I think, for us to grapple with. Yeah,
and we quote Audre Lorde too in the first chapter of the book, I think, with the introduction. She says you can't use the master's tools to dismantle the master's house. And I think the Feminist Judgments Project tries to challenge that. I'm not sure it succeeds, but it tries to. And I think that's an interesting process. But I agree, Carol Smart, she also tells us to decenter the law. And I still think that's absolutely true for feminists. I think that, you know, it does seem to be quite hard to get law right, whether it's legislation or case law right for women. There's so many unintended consequences from so many of the things that we introduce, and it seems the law is peskily difficult to move. I'm looking at these new consent laws in New South Wales, and you know, they sound better, but I'm wondering what will happen. And same with the questions around coercive control and introducing that. So yeah, look, I think it has tried to challenge that point and has tried to dismantle some of the assumptions that go with the patriarchy. Whether it did that, I don't know.